Good morning, ma'am. I'm here to present about the Module 4 of CA 200. Topics: the Bureau of Corrections or RA 10575, Custody, Security and Control of Prisoners, Care and Treatment of Prisoners, Release of Prisoners, Good Conduct Time Allowance or GCTA, Prohibited Acts Subjects to Disciplinary Actions, BGMP, RA 6975, Republic Act 9263, Treatment of Special Needs or Unusual Offenders, Emergency Plans, Movement or Transfer of Prisoner or Trainees, Privileges of Detainees and Sentenced Prisoners, and last is the Regional Rehabilitation Centers for Youth, the Child and Youth Welfare Code, the Death Row, and the Rule of Writ of Amparo. The Bureau of Corrections RA 10575, Republic Act of 10575, an act strengthening the Bureau of Corrections, BUCOR, and providing funds, therefore, be it enacted by the Senate and the House Representatives of the Philippines in Congress assembled. Section 1, short title. This act shall be known as the Bureau of Corrections Act of 2013. Section 2, Declaration of Policy. It is the policy of the state to promote the general welfare and safeguard the basic rights of every prisoner incarcerated in our national penitentiary. It also recognizes the responsibility of the state to strengthen government capability aimed towards the institutionalization of highly efficient and competent correctional services. Towards this end, the state shall provide the modernization, professionalization, and restructuring of the Bureau of Corrections or the BUCOR by upgrading its facilities, increasing the number of its personnel, upgrading the level of qualifications of their personnel and standardizing their base pay, retirement, and other benefits, making it par Section 3. Definition of terms. Safekeeping, which is the custodial component of the BUCOR's present correction system, shall refer to the act that ensures the public, including families of inmates and their victims, that national inmates are provided with their basic needs, completely incapacitated from further committing criminal acts, and have been totally cut off from their criminal networks or contacts in the free society while serving sentence inside the premises of the National Penitentiary. B. Reformation, which is the rehabilitation component of the BUCOR's present correction system, shall refer to the acts which ensures the public, including families of inmates and their victims, that released national inmates are no longer harmful to the community by becoming reformed individuals prepared to live a normal and productive life upon reintegration to the mainstream society. Section 4. The mandates of the Bureau of Corrections. The BUCOR shall be in charge of safekeeping and instituting reformation programs to national inmates sentenced to more than 3 years. Safekeeping of national inmates. The safekeeping of inmates shall include decent provision of quarters, food, water, and clothing in compliance with established United Nations standards. The security of the inmates shall be overtaken by the custodial force consisting of corrections officers with a ranking system and salary grade similar to its counterpart in the BGMP. Reformation of the national inmates. The reformation programs which will be inserted by the BUCOR for the inmates shall be the following: 1. Moral and spiritual program. 2. Education and training program. 3. Work and livelihood program. 4. Sports and recreation program. 5. Health and welfare program. And 6. Behavior modification program to include the therapeutic community. C. The reformation programs shall be undertaken by professional reformation personnel consisting of corrections technical officers with ranking system and salary grades similar to correction officers. Corrections technical officers are personnel employed in the implementation of reformation programs and those personnel whose nature of work requires proximate or direct contact with inmates. 2. Corrections technical officers include priests, evangelists, pastors, teachers, instructors, professors, vocational placement officers, librarians, guidance counselors, physicians, nurses, medical technologists, pharmacists, dentists, therapists, psychologists, psychiatrists, sociologists, social workers, engineers, electricians, agriculturists, veterinarians, lawyers, and similar professional skills relevant to the implementation of inmate reformation programs. Section 5. Operations of the Bureau of Corrections. The Bureau shall operate with a directorial structure. It shall undertake reception of inmates through its Directorate for Reception and Diagnostics, DRD, formerly Reception and Diagnostic Center, or RDC, provide basic needs and security through its Security and Operations Directorates, administer reformation programs through its Reformation Directorates, and prepare inmates for integration to mainstream society through the Directorate for External Relations, DER, formerly External Relations Division, or ERD. B. The DRD shall be responsible for the conduct of classification of each and every inmate admitted to the Bucor. Inmates shall be classified according to security risk and sentence. Section 7. Facilities of the Bureau of Corrections. The Bucor shall operate with standard and uniform design of prison facilities, reformation facilities, and administrative facilities through all the operating prison and penal farms, such as the following: A. Dormitory. B. Administration building. C. Perimeters or security fences. D. Hospital infirmary. E. Recreation or multi-purpose hall. F. Training lecture center. G. Workshop facility. H. Mess hall or kitchen. I. Visiting area. And G. Water tank and pump. Section 8. Supervision of the Bureau of Corrections. The Department of Justice, or DOJ, having the Bucor as a line bureau and a constituent unit, shall maintain a quarter relationship of administration supervision with the latter as defined under Section 38 or 2, Chapter 7, Book 4 of Executive Order Number 292, Administrative Code of 1987, except that DOJ shall retain authority over the power to review, reverse, revise, or modify the decisions of the Bucor in the exercise of its regulatory or quasi-judicial functions. Section 9. Organization and the key positions of the Bureau of Corrections. The Bucor shall be headed by a director who shall be assisted by 3 deputy officers, 1 for administration, 1 for security and operations, and 1 for reformation, all whom shall be appointed by the President upon the recommendation of the security of the DOJ, provided that the director and the deputy director of the Bucor shall serve a tour of duty not to exceed 6 years from the date of appointment, provided further that in times of war or other national emergency declared by the Congress, the President may extend such tour of duty. The head of the Bucor with the rank of Undersecretary shall have the position and the title of Director General of Corrections. The second officers in command in the Bucor with the rank of Assistant Secretary shall have the position and title of Deputy Directors of Corrections. The third officer in command of the Bucor with the rank of Chief Superintendent shall have the position, title of Corrections Chief Superintendent. The fourth officer in command in the Bucor with the rank of Senior Superintendent shall have the position and title of Corrections Senior Superintendent. The fifth officer in the command in the Bucor with the rank of Superintendent shall have the position with the title of Corrections Superintendent. C. The Department of Budget and Management, or TBM, shall rationalize the existing organizational structure and staffing patterns of the Bucor in accordance with the provisions of the Act and relevant compensation and position classification laws, rules, and regulations. Provided that in prison and penal farms with an inmate population of 3,000 but below 5,000, the regional superintendent shall have the rank and qualifications of colony senior superintendent. Provided further that in prison and penal farms with an inmate population of over 5,000, the regional superintendent shall have the rank and qualifications of superintendent. Any personnel of the Bucor who is currently occupying such as positions but lacks any of qualifications mentioned therein will be given 5 years to comply with the requirements other than the personnel shall be relieved from the position. Section 15. Professionalization and Qualifications Upgrading Program. The DOJ shall design and establish a professionalization and qualifications upgrading program for personnel of the Bureau in coordination with the CSC and the Commission on Higher Education or CHED through an off-campus education program or similar programs within 90 days from the effectivity of this act. Section 16. Attrition System of the Personnel of the Bureau. There shall be established a system of attrition for the personnel of the Bureau within 5 years from the effectivity of this act to be submitted by the said Bureau to the DOJ for approval. Such attrition system shall include, but is not limited to, the provisions of the following principles. A. Attrition by demutilation in position or rank. Any personnel of the Bureau is relieved and assigned to a position lower than what is established for the grade in the respective staffing pattern and who shall not be assigned. Attrition by demolition in position or rank. Any personnel of the Bureau is relieved and assigned to the position lower than what is established for the grade in the respective staffing pattern and who shall not be assigned to a position commensurate to one's grade within 2 years after such demotion in position shall be separated or retired from the service. Attrition by non-promotion. Any personnel of the Bureau who has not been promoted for a continuous period of tenure shall be separated or retired from the service, except for those who are occupying a third-level position. C. Attrition by other means. Any personnel of the Bureau with at least 5 years of accumulated active service shall be separated from the service based on any of the following factors. Inefficiency based on poor performance during the last 2 successive semestral rating periods. Inefficiency based on poor performance for the 3 cumulative semestral rating periods. Physical and or mental incapacity to perform one's duties and functions, or failure to complete the required career courses and or operation service. Civil eligibility for his or her position except for justifiable cause or reason, and separation or retirement from the Bureau under this section. Any personnel who is dismissed from the Bureau pursuant to the above enumerated principles in this section shall be separated if one has rendered less than 20 years of service and be retired if one has rendered at least 20 years of service less than the concerned personnel. Section 17. Promotion System for the Personnel Act of the Bureau. Within 6 months after the effectivity of this act, the Bureau shall establish a system of promotion for the personnel of the Bureau through the following principles. Section 17. Promotion System for the personnel of the Bureau. Within 6 months after the effectivity of this act, the Bureau shall establish a system of promotion for the personnel of the Bureau through the following principles. A. Rationalized promotion system. The system of promotion shall be based on merit and the availability of vacant ranks in the Bureau staffing pattern. Such system shall be gender fair so as to ensure that women personnel of the Bureau shall enjoy equal opportunity for promotion as to men. B. Requirements for promotion. Any personnel of the Bureau shall not be eligible for promotion to a higher rank unless one has met the minimum qualification standards or the appropriate civil service eligibility set by the CEC. Section 18. Performance Evaluation System. There shall be established a performance evaluation system which shall be administered in accordance with the rules, regulations, and standards and the code of conduct for the personnel of the Bureau to be promulgated by the Bureau through the DOJ. Such performance evaluation system shall be administered in such a way as to foster the improvement of the individual efficiency and behavioral discipline, as well as the promotion of organizational effectiveness and commitment to public service. B. The rating system as contemplated herein shall be based on standards prescribed by the Bureau through the DOJ and shall be considered the result of the annual psychiatric or psychological and psychiatries conducted on the personnel of the Bureau. Section 19. Standardization of the base pay and other benefits of the uniformed personnel of the Bureau. In order to enhance the general welfare, commitment to service and professionalism, the following are considered uniformed personnel of the Bureau. What is Good Conduct Time Allowance? Good Conduct Time Allowance, or GCTA, is a sentence reduction provision afforded prisoners who show good behavior. It has been in existence since 1906. Act 1533 provided for the diminution of sentences imposed upon prisoners in consideration of good conduct and diligence. Citing a 1908 decision, the SC said the law served a double purpose: to encourage the convict in an effort to reform unjust habits of industry and good conduct, the person beyond one sentence, and aid to discipline various jails and penitentiaries. What is RA 10592 and how does it work? In May 2013, then President Benigno Noynoy Aquino III signed RA 10592, amending Articles 29, 94, 97, 98, and 99 of the RPC, which sought to expand the application of the GCTA to those under preventive imprisonment or those detained prior and during the criminal trial, who are deemed to do dangerous for release. Increase the number of 5 days that may be accredited for GCTA. Allow an additional sentence deduction of 15 days for each month of study, teaching, or mentoring services. Who can benefit from the law? Inmates who display good behavior and have no record of breach of discipline or violation of prison rules and regulations may be eligible for GCTA. According to the Bucor Operating Manual, as cited in the SC decision, the IRR of RA 10592 defines good behavior as the conspicuous and satisfactory behavior of a detention or convicted prisoner, consisting of active involvement in rehabilitation program, productive participation in authorized work activities or accomplishments of exemplary deeds, coupled with faithful obedience to all prison jail rules and regulations. A. Fire or Jail Officer 1 to Senior Fire or Jail Officer 4, appointed by the respective Regional Director for Fire Protection and Regional Director for Jail Management and Penology. For the Regional Office Uniform Personnel, or by the respective Chief of the Fire Bureau and Chief of the Jail Bureau. For the National Headquarters Office Uniform Personnel, and attested by the Civil Service Commission or the CSC. B. Fire Jail Inspector to Fire Jail Superintendent, appointed by the respective Chief of the Fire Bureau and the Chief of the Jail Bureau, as recommended by their immediate superiors and attested by the CSC. Fire Jail or Senior Superintendent, appointed by the Secretary of the DILG, upon the recommendation of the respective Chief of the Fire Bureau and Chief of the Jail Bureau and Penology. D. Fire or Jail Chief Superintendent to Fire Jail Director, appointed by the President upon recommendation of the Secretary of the DILG with a proper endorsement by the Chairman of the CESC. Lateral entry of officer into the PFP and the BGMP. In general, all or general appointment of the officers of Fire Bureau and Jail Bureau shall commence to the rank of Fire or Jail Inspector within applicants for lateral entry in the PFP, shall include all those with highly specialized and technical qualifications such as but not limited to civil engineers, mechanical engineers, electrical engineers, chemical engineers, chemists, architects, criminologists, certified public accountants, nurses, physical therapists, dentists, while applicants for lateral entry to the BGP shall include all those with highly specialized and technical qualifications, such as but not limited to social workers, psychologists, teachers, nurses, dentists, and engineers. Doctors of medicine, members of the Philippine Bar, and chaplains shall be appointed to the rank of the jail or fire senior inspector in their particular technical service. Graduate of the Philippine National Police Academy or the PNPA shall be automatically appointed to the initial rank of Fire or Jail Inspector. Section 7. Professionalization of and upgrading of qualification standards in the designation of uniformed personnel of the BFP and the BGMP to key positions. No person shall be designated to the following key positions of the BFP and the BGMP unless he or she has met the qualifications provided therein. Municipal Fire Marshal should have the rank of Senior Inspector, who must have finished at least second-year Bachelor of Laws or earned at least 12 units in Master's degree. Program in Public Administration. management, engineering, public safety, criminology, or other related discipline from the recognized institution of learning and must have satisfactorily passed the necessary training of career courses for such positions as to be thus established by the Fire Bureau. The role on the writ. The role on the writ of the Amparo Supreme Court of the Philippines. Section 1. Petition. The petition for a writ of amparo is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of public official or employee, or of private individual or entity. The writ shall cover extra-legal killings and enforce disappearance of or threats thereof. Section 2. Who may file the petition may be filed by the aggrieved party or by any qualified person or entity in the following order. B. Any ascendant or descendant or collateral relative of the aggrieved party within the fourth civil degree or consanguinity or affinity in default of those mentioned in the preceding paragraph. Or C. Any concerned citizen, organization, association, or institution if there is no known member of the immediate family or relative of the aggrieved party. The filing of the petition by the aggrieved party suspends the right of the other authorized parties to file similar petitions. Likewise, the filing of the petition by an authorized party on behalf of the aggrieved party suspends the rights of all unobserving. Section 3. Where to file. The petition may be filed on any day at any time with the regional trial court of the place where the threat or act of omission was committed or any of the elements of court, or with the Sandigan Bayan, the Court of Appeals, the Supreme Court, or any justice of such courts. The writ shall be enforceable anywhere in the Philippines. When issued by a regional trial court or any judge thereof, the writ shall be returnable before such court or judge. When issued by the Sandigan Bayan or the Court of Appeals or of their justices, it may be returnable before such court or any justice thereof, or to at any regional trial court of the place where the act or omission was committed. The accredited persons and private institutions shall comply with the rules and conditions that may be imposed by the court, justice, or judge. Inspection order. The court, justice, or judge, upon verified motion and after the due hearing, may order any person in possession or control of the designated land or other property to permit entry of the purpose of inspecting, measuring, surveying, or photographing the property or any relevant object or operations thereon. The motion state shall entail the place or places to be inspected shall be supported by the affidavits or testimonies of witnesses. If the motion is opposed on the ground of the national security or of the privileged nature of the information, the court, justice, or judge may conduct a hearing in chambers to determine the merit of the opposition. The movement must show that the inspection order is necessary to establish the right of the aggrieved party alleged that threatened or violated. The inspection order shall specify the person or persons authorized to make the inspection and date, time, place, and manner of making the inspection, and may prescribe other conditions to protect the constitutional rights of all parties. C. Production order. The court, justice, or judge, upon verified motion and after due hearing, may order any person in possession, custody, or control of any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things or objects in digitized or electronic form which constitute or contain evidence relevant to the petition or the return to produce and permit their inspection, copying, or photographing by or on behalf of the movant. The motion may be opposed on the ground of the national security or the privileged nature of the information, in which case the court, justice, or judge may conduct a hearing and chambers to determine the merit of the opposition. The court, justice, or judge shall prescribe the conditions to protect the constitutional rights of all the parties. Witness protection order. The court, justice, or judge, upon motion or motu proprio, may refer to the witness of the Department of Justice for administration to witness protection, the security and benefit program pursuant to the Republic Act of 9681. The court, justice, or judge may also refer the witnesses to other government agencies or to accredited persons or private institutions capable of keeping and securing their safety. Section 15. Availability of interim realms to the respondent. Upon verified motion of the respondent, and after due hearing, the court justice or judge may issue an inspection under or production order under paragraphs B and C of the preceding section. A motion for inspection order under the section shall be supported by affidavits or testimonies of witnesses having the personal knowledge of the defenses of the correspondent. Section 16. Contempt. The court, justice, or judge may order the respondent who refuses to make a return or make a false return, or any person who otherwise disobeys or resists a lawful process of order of the court to be punished for contempt. Section 25. Supplementary application of the rules of the court. The rules of court shall apply supplementary insofar as it is not consistent with this rule. Section 26. Applicability to pending cases. This rule shall govern cases involving extralegal killings and enforced disappearance or threats thereof pending the trial and appellate courts. Section 27. Effectivity. This rule shall take effect on October 24, 2007, following its publication in 3 newspapers of the general circulation. Thank you for listening.